What would you say if I told you that Roe v. Wade wasn't really about abortion? It was actually about the government knowing its place and staying out of yours. By overturning the ruling, the government didn't just ban protections around abortion. They gave themselves permission to enter spaces where they previously were not legally allowed. And if you think it's going to stop there, you haven't been paying attention. We spent the last 50 years arguing about a medical procedure and completely missed the legal trick happening in the background. Roe v. Wade was built on something called the zone of privacy. You see, the case of Roe v. Wade was brought to the court on the basis of abortion. A mother in Texas did not want to continue her pregnancy, but the state of Texas felt that violating her personal choice was less of a concern than the potential life in her womb. The legal doctrine used to support that mother's argument that she had a legal right to privacy was the 14th Amendment's Due Process Clause, which prohibits the deprivation of life, liberty, and property. Now, unlike many other constitutional democracies, the United States Constitution does not give an explicit right to privacy. Instead, this right has been judicially constructed through two distinct, though theoretically linked, lineages. Decisional privacy, rooted in the 14th Amendment's Due Process Clause, which we call substantive due process, and informational privacy, rooted in the Fourth Amendment's right against illegal searches and seizures. Now, the good news, the Supreme Court decided the Bill of Rights casts shadows, or penumbras, and in those shadows, they found an invisible force field that the 14th Amendment puts around your personal choices. In short, the 14th Amendment was defined in Roe as a protection of your right to privacy, while maintaining the state's interest in a protection of life. Now, for a while, that force field of protection held, but while we were busy fighting culture wars, arguing about whether or not women have a right to the jurisdiction of their own body, the courts, the intelligence community, and data brokers were silently dismantling your rights. They were quietly using something called the third-party doctrine. Here's the smart thing they don't teach you in civics class. The third-party doctrine states that the moment you voluntarily give up your privacy rights to a third party, a bank, a phone company, a period tracking app, you lose your reasonable expectation of privacy. And by using that service that you may or may not have a choice in whether or not you use it, you've already voluntarily given up your right to privacy. That legal loophole is the entire business model of the 21st century. And you think it's coincidence that Roe fell around the time when data brokering became a multi-billion-dollar industry? I think not. Now, while the court was recalibrating decisional privacy after Roe, it was also engaging in a parallel struggle to define privacy in the context of information and law enforcement. The modern Fourth Amendment is built on Katz v. United States from 1967, which held that the amendment protects people, not places. Katz established that a search occurs when the government violates a person's reasonable expectation to privacy. However, in the 1970s, the courts carved out a massive exception to this, which was the third-party doctrine. In United States v. Miller in 1976, the court held that a bank depositor has no reasonable expectation of privacy. Things like checks, deposit slips became accessible information. And then in Smith v. Maryland in 1979, the court extended this logic to telephone numbers. Throughout the 1980s and 1990s, this continued. The reasonable expectation of privacy was extended to the war on drugs. The court prioritized law enforcement efficacy, ruling that digital surveillance of backgrounds did not violate personal privacy. Even searching through someone's garbage at the curb was allowed and did not violate the Fourth Amendment. The prevailing judicial philosophy was that if a member of the public could access this information by flying over a house or looking in a trash can, the police did not need a warrant to do so. This public exposure doctrine ran parallel to the third-party doctrine, creating a legal environment where privacy was increasingly defined by what you could hide inside the walls of your home. And then came the pivot point, September 11th, 2001. Before 9/11, privacy was a shield for the citizen. After 9/11, it was framed as a hiding spot for terrorists. We panicked. We passed the U.S. Patriot Act, specifically Section 215. Passed just a few weeks after the 9/11 attacks, the Patriot Act amended the Foreign Intelligence Surveillance Act to lower the threshold for obtaining surveillance warrants. Section 215 allowed the FBI to obtain an order from the Foreign Intelligence Surveillance Court requiring the protection of any tangible things, including books, records, documents, for an investigation to protect against international terrorism. Do you see where I'm going with this? In secret, the government interpreted tangible things to include the entire database of detailed call records, metadata, from major telephone companies. Relying on Smith v. Maryland, the court argued that because this was metadata, who called whom, when, and for how long, and not content, what was said, and because it was held by third-party telecommunications companies, there was no Fourth Amendment protection. With the Patriot Act, we swapped liberty for security and got neither. We socially engineered an entire generation to believe the most dangerous lie in American history. If you have nothing to hide, you have nothing to fear. That slogan convinced us to allow the NSA to build haystacks of our metadata. We watched Edward Snowden pull back the curtain in 2013, we gasped, and then we just kept scrolling. We accepted the price of a free and open internet is total surveillance. And now, fast forward to 2025. The national security excuse has trickled down from counter-surveillance to local policing. We have something called geoforce warrants. This is a trend you need to be terrified of. Police don't need to track you specifically. They just draw a digital circle around a location, say a reproductive clinic or a protest, and Google hands over the digital ID of every device that entered that circle. It's a digital dragnet. And don't look to Congress to save you. We have something called Protecting Americans' Data from Foreign Adversaries Act. Sounds noble, right? Great branding. But it's just another act of optics. It restricts selling your data to China, but it leaves the door wide open for American companies to sell that same data to American law enforcement. There's a reason the current administration wants to limit AI enforcement. It is a loophole the size of the internet. The government often cannot legally seize your data without a warrant, but they can simply buy it from a data broker like Fog Data Sciences for the cost of less than a used car. We are fighting for a free and open internet while living in a digital panopticon. They want you arguing about the morality of what happens in a doctor's office so that you don't notice that your data is being auctioned off to the highest bidder. The systems that were built to catch terrorists are now being retuned to catch anyone who falls outside of the norm. When privacy rights erode, they don't disappear for the rich. They disappear for the vulnerable. The system is not exactly broken. It's working exactly as it was designed. It's harvesting your information and slowly peeling back any semblance of privacy you might still have. Now, go check your location settings. Not that it might matter.